So next, I want to introduce one of our new colleagues at Foley. We are very happy to have her, Jennifer Belveal. She is a partner at Foley in our litigation department, and she is going to be talking to you today about recent developments under the False Claims Act.
Good morning, everyone. Please help yourself to get up and get some more coffee, move around a little bit, except for those, I guess, on the webinar. Don't step away too long because you do have to put the code in the box when it pops up, but feel free, please, now and throughout this presentation to take a break and grab some coffee. I'm going to be talking to you today about recent developments under the False Claims Act. I come at this from a little bit different background or approach. I am a litigator, as Erin said. I do both commercial business disputes as well as white-collar criminal defense, regulatory work, a lot of internal investigations. So basically, my objective here today is not to scare you, although some of the information and statistics I'm going to give you about how the government is becoming more aggressive on this topic may seem a bit frightening. Really, my goal here today is to give you the background in the working knowledge, so hopefully you don't have to hire me to defend you or your company at some point, because that's even a very unpleasant experience. And I know a lot of you are in the position where you're going to be going back to your organizations after today, and you're the no-sayer, telling the rest of your organization what it is they need to know so that they don't get into trouble. And hopefully some of the information I'm giving you here today will arm you so that you'll be in a better position to make sure that you're compliant in all the possible ways. So I'm going to actually talk about 5 areas this morning. I'm going to talk a little bit about the False Claims Act statistics, what's happening on the forefront, why is this area such an increased risk to government contractors. I'm going to give you also a quick refresher on the False Claims Act. I find that a lot of people throw around the phrase the FCA or the False Claims Act without really getting an understanding of what it is. Most people don't understand that when you talk about the False Claims Act or when you see it in print, it's a little bit of a misnomer, because the False Claims Act actually is not a single act. It's not one piece of legislation. And sometimes you're not even sure what someone's talking about when they're talking about the False Claims Act, because you have to dig a little bit to figure that out. I'm also going to give you a real quick case law update. There was one very large Supreme Court decision this past June, if you didn't see it, the Escobar case, which has a very big impact on the way False Claims Act cases, I think, are going to be prosecuted or brought forward on an ongoing basis, and it really has an impact in the government contracts area. I'm also then going to give you a little bit of information about some recent legislative activity in this area, which unfortunately makes it even scarier for you who are doing government contracts. And then I'm going to end, though, today on a little bit of an optimistic note. I'm going to tell you the number one tip that hopefully all of you can take back and take a look at that will cut your or reduce your risk in the False Claims Act area. So starting off with recent statistics. Why is everybody talking about the False Claims Act? I mean, you'll see it in the newspaper, you see it in trade journals. Why is this such a hot topic these days? Well, the reason why is money, right? Everything seems to always come down to money. And the False Claims Act literally is a billion-dollar business. The Department of Justice has obtained more than $26 billion in false claim settlements and judgments just since January of 2009. In 2015, which is the last year, of course, that we have full year statistics, it was the 4th consecutive year in which the Department of Justice recouped more than $3.5 billion in false claims violations in a single year. And for the first half of 2016, we're on track to either meet that large dollar penalty or exceed it with more than $1.86 billion in False Claims Act recoveries just for the first half of 2016. The number of False Claims Act, not just the dollars, but the actual numbers of claims being brought are increasing as well. For the 6th year in a row here, over 700 new False Claims Act matters were put on court dockets in 2015, And remember, not even all cases hit the court docket. And more than 600 of those were filed under the False Claim Act whistleblower or qui-tam provisions, meaning they were brought by an individual initially and not by the government. False Claims Act cases involving government contractors in particular are getting a lot of attention these days, in large part because of the Supreme Court decision that came out over the summer. There was a little bit of unsettled area, and frankly, in some respects, the recent decision has opened up the floodgates a little bit even more in the False Claims Act area. I also want to just talk for a moment about some of the settlements that are happening these days, because most of these cases do, in fact, like all litigation, get settled. Very costly and painful, not only in terms of dollars that you have to spend often to settle them, but also just the pure time involved, the lost opportunity cost, because you have to devote so much time to usually an internal investigation and to work out some sort of resolution with the government. So in January of 2016, earlier this year, there was a $9 million False Claims Act settlement against a design and construction firm that allegedly concealed it had already engaged in joint venture partners for a USAID project before the actual bid was submitted. In February of this year, there was a $7.4 million False Claims Act settlement against a subcontractor of services at a military base for allegedly double billing certain salaries as both direct and indirect costs. Also in February of this year, there was a $4 million settlement against a government contractor for allegedly violating environmental laws and then making claims for Department of Energy funds that indicated compliance with those laws. In March of this year, there was a $5 million false claim settlement against a government contractor that allegedly misrepresented itself as a veteran-owned business. That is, again, one of the specifically hot areas right now is veteran-owned businesses as well as minority-owned businesses. The government is really cracking down on that and parsing to see whether or not those are accurate statements. In March of this year as well, there was an $8 million false claim settlement against an Army contractor for misrepresenting the source of raw materials. So you can see why the False Claims Act is getting so much attention, because there's really a lot of dollars involved here. So let me give everybody a quick refresher on the False Claims Act. The False Claims Act, as I alluded to earlier, actually could refer to 3 different statutory schemes, even though everybody refers to it as the False Claims Act. There is, first, the Civil False Claims Act, which of course is a federal statute. There is also the Criminal False Claims Act, the difference being, of course, that you have to have some sort of criminal intent for a criminal violation, but that's often what I'm arguing, quite frankly, with the government about and regulators about, whether or not when a problem is found, whether or not it should be a civil violation or a criminal violation. Sometimes you have parallel proceedings. And then on top of it, if you do state government contracts, you may be aware that there are state mini versions of the False Claims Act, which often track the federal statute, but they have some variances. And both on the federal level and the state level, if we're talking about civil claims, the big danger, of course, with False Claims Act is that an individual whistleblower can bring an action, and so that's a whole new level of concern, creates a lot of suspicion, I think, within companies as well. But that's really the big danger these days, is because, as Erin was saying, the government may not have all the resources to go out and audit and find problems, but you might have a mole right in your very own company who's disgruntled for some reason, who can suddenly, bring the wrath of the government down with these very large penalties. So you have a risk of false claims liability if you submit a money-related claim to the government. The submission is false and you do so knowingly. I know that seems pretty simple, but actually these types of claims can be further broken down. Oh, no, that's all right. Do you want me to read the code? The code is DYFDJ.
Are you on the slide where they can type it in?
Again, the code is DYFDJ.
Just for those on the phone.
So the types of false claims can be broken down into a few different areas. You have what's called a factually false claim, which actually can further be broken down into a false claim or a false record. I'll talk about that in a moment. You have what's called a legally false claim, which could involve an express certification or an implied certification. And then you have what's called a reverse false claim. Factually false claims, these are the easiest ones. This is when there is a known inaccuracy in an affirmative statement of supporting documentation. So false claim is when the statement itself is false. A false record, which also constitutes a false claim, is when your supporting documentation has an inaccuracy. Examples of a factually false claim include misrepresenting the work done or the amount due, the most straightforward type of false claim you could have, submitting false bid documents, or, for example, misrepresenting the role of a disadvantaged business in a project. Reverse false claims, I'm going to get back to implied certifications and express certifications in a moment because those are the most controversial and the most difficult. So I'm just going to skip that for now and move on to reverse false claims. Reverse false claim is the failure to pay money to the government based on a known inaccuracy. So essentially what we're talking about is unlawfully retaining government funds. How does this come up in the government contracting area? One example would be falsely accounting for government property in your possession to avoid having to compensate the government for it. So if you've got some sort of government property that you're supposed to be, accounting for on a regular basis, but instead you retain the funds, that could be a reverse false claim. Let's talk about certification. This is actually the dicier gray area that more often trips up companies than the other areas, which are fairly clear. Mistakes can be made, but fairly clear. An express false certification involves a knowingly false statement of compliance with some sort of payment requirement. Examples of an express false certification is misrepresenting that all subcontractors have been paid, or another example would be misrepresenting that the work meets contract requirements when it really doesn't. An implied false certification is the last type of different claims here. Here we're talking about the failure to disclose material violations of statutory, regulatory, or contractual requirements of payment. So what does that really mean? That means that there's an affirmative obligation on a government contractor to bring to the government's attention that there has been a violation of a material violation, I'll talk about that in a moment, but a violation of some sort of requirement that's imposed on the contractor. Doesn't even have to be, as we'll talk about, an express requirement for payment, but you are required to disclose that. Examples would be failure to pay the applicable wages, seeking reimbursement for work that doesn't meet the qualifications. Before the Supreme Court ruling in Escobar this summer, the validity and the scope of this implied certification theory was unclear. After the Supreme Court's ruling, it's a little bit more clear where this is going. So you may have heard a lot about Escobar. I want to step back for a minute and explain to you what the case actually involved. It was a healthcare case. In that particular case, a teenage patient suffered a fatal seizure after receiving mental health counseling at a clinic. The patient's parents sued under the False Claims Act. So these were these individuals, we often call them whistleblowers. Here it wasn't even an employee, but it was a customer or a patient's parents. They alleged under the False Claims Act that staff members were not properly licensed or supervised as required by government regulations to treat their child's seizure, and by billing for the counseling services through government, I don't know if it was Medicare or Medicaid, I don't recall at the moment, they implied that they were certifying that the services when performed by these staff members was in compliance with all government regulations, even though, again, it was not an express requirement of the reimbursement, the federal health care reimbursement. And so for the first time, the Supreme Court really addressed, would this type of implied certification form the basis of a False Claims Act? On the one hand, you had a lot of people saying, frankly, in defense of government contractors, how can a government contractor be responsible for knowing every single rule and regulation out there? And so when they apply for payment, that they're, implicitly certifying that they've complied with everything out there in the universe. That seems like a huge burden to impose on a government contractor. On the other hand, you had individuals, mostly in support of the government, saying, well, if it's a material important thing, we do require all contractors generally to know what they're doing. And what did the Supreme Court say? The upshot of Escobar is it's a little bit controversial, or I should say conflicting, on what the outcome is. On the one hand, the Supreme Court absolutely decided that implied certification is a valid theory under the False Claims Act. So now anybody who wants to bring a False Claims Act violation based on this implied certification can do so. But the Supreme Court also threw a little bit of bone back to the government contractors, recognizing that it was a huge burden to impose on contractors to be responsible for everything. So what the Supreme Court did is they said that you had to look at the, quote, rigorous and demanding materiality standard for what constituted a violation. So broken down a little bit further, implied certification is now a viable theory under the False Claims Act if two conditions are satisfied. Number one, and these are quotes, I should say, directly from the Supreme Court opinion, the claim does not merely request payment, but also makes specific representations about the goods or services provided. And the defendant's failure to disclose noncompliance with material statutory, regulatory, or contractual requirements makes those representations misleading half-true. Okay, it sounds like a lot of words. Let's see if we can break it down even further. So what the Supreme Court said was defendants can be liable for violating government requirements even if they were not expressly designated as conditions of payment. But in order for those requirements to form the basis of a False Claims Act violation, they must be material violations. Again, the court said a material violation was any, quote, misrepresentation about compliance with a statutory, regulatory, or contractual requirement that was material to the government's payment decision in order to be actionable. And they said that the materiality standard is rigorous, demanding, and subject to strict enforcement. Lots of adjectives and adverbs here, but is there any objective standard? No. In fact, they said there was no bright line rule. Instead, they wanted to look kind of general understanding of what people in the industry may think. And they said specifically, under any understanding of the concept, materiality looks to the effect on the likely or actual behavior of the recipient of the alleged misrepresentation. So for example, and this was an example from the Supreme Court, if a defendant knows that the government consistently refuses to pay claims in the mine run of cases based on noncompliance with a particular statutory, regulatory, or contractual requirement, then by not meeting that requirement too and submitting a claim for payment, it could be the basis of a false claim. Are all payment requirements material? The Supreme Court said no. They said that statutory, regulatory, and contractual requirements are not automatically material, even if they are labeled conditions of payment. So what does that all mean? Kind of a mess right now, frankly, and it's probably going to take a number of years until the court sorts this out. in the Escobar case itself, the Supreme Court didn't even make a ruling as to whether or not the government claim against the defendant was sufficient. Instead, they remanded it back, and that's being dealt with right now in the First Circuit. So I think there's going to be a lot of decisions you're going to see out of various cases as to exactly what this means. And we don't all know yet. We don't have a crystal ball. What it really means, though, is you have to be much more careful about looking at all of your compliance aspects when you're dealing with a government contract. Examples of implied certification in government contracts include knowingly supplying materials of lesser quality than specified. Again, to me, that's a little bit clear because you're specifying exactly what the quality is. But another type of implied certification would be billing for work performed by a non-engineer when the contract requires work to be done by a licensed professional engineer. So you have to kind of look at all aspects now of compliance. The bottom line when it comes to Escobar is if there is a material, statutory, or regulatory non-compliance issue in connection with a government contract, there is now a risk of a False Claims Act claim being brought against you. It's no longer just a regulatory issue that you didn't comply, dot all your I's, cross all your T's. Now you could be facing one of the multi-million or billion-dollar claims based on this. So I want to also talk about, yes, we have a question back here. So the question was, under Escobar now, are all type of regulatory compliance issues involving employment issues, sourcing issues, all of those minute things that frankly fill up lots of government regulations, the types of things that you have to be wary about? And the answer is, we don't know. You have to certainly be wary of what I'll call the big ones, and that's going to vary, right? There'll be some commonality, but it's going to vary oftentimes on what your contract is, what the services or goods are that are being supplied, as to how much of a red flag issue it is. I don't think that it's probably realistic, given government resources, that government would get down, to the very minutia of everything. But if it's a big deal, either because of an industry, because of, frankly, politics, what's going on in the world, I think you mentioned, the sourcing of materials and where those are the types of things that are now likely going to rise to the attention. And frankly, with regard to the fact that whistleblowers can bring these claims, a lot of people are professional whistleblowers. They go around, and it's been proven, particularly in the healthcare industry, to go to different organizations looking to make their money off of bringing False Claims Act cases. So you have to be very careful of knowing your industry, your business, what are the hot topics right now, what are people looking at, and it's probably going to change over time, even as we get more information as to how the Escobar case is going to be actually applied. So moving on to the legislative front. Always under the False Claims Act, the reason why we talk about so many dollars being involved is that there are treble or triple damages that you can be liable for under the False Claims Act, and also civil monetary penalties, or CMPs. Effective August 1st of this year, the False Claims Act, this is of course the Federal False Claims Act, minimum and maximum civil monetary penalties nearly doubled. They went from a minimum of $5,500 and a maximum of $11,000 to a minimum of $10,781 and a maximum of $21,563. So again, the amounts going up, and when you talk about triple damages on top of this, this is how we get into the billion-dollar figures. Don't forget as well, even though this is not something that's new, there are a number of other what I'll call ancillary consequences or penalties that can arise in the False Claims Act situation. The relator or the whistleblower not only gets their share or their cut of what the resolution or payment is, but they're also entitled to their attorney's fees. Those can be substantial. And the other collateral consequence is that a company can be debarred from government contracting in the future. So essentially, there goes your opportunity because there's a False Claims Act violation. So now that everybody is sufficiently scared because Escobar has created a lot of uncertainty and there's lots of dollars involved, what's the top way to reduce your risk of False Claims Act liability? And quite simply, and this is going to sound, of course, easier than I understand it is to really tune up your compliance program. Take a fresh look at your compliance program. You should be doing that anyway on a fairly regular basis. But these are the top things you need to look at when you pull out the compliance program. Do you have clear tone at the top? Are your management folks and both orally and in written materials saying the right things about complying with all regulations, statutes, et cetera? Are you not only using that tone at the top to say it, but then to actually inform people when there's changes in rules and regulations? So you have some process in place to make sure that the tone at the top says the right things and disseminates information down. I know it sounds simple. Again, tone at the top is one of the #1 things when I'm negotiating with the government, whether it should be a criminal penalty or a civil penalty and exactly what the penalty should be that they look at. So it's one of those things that you just have to do, because the worst thing is sitting across the table from a government lawyer and they say, well, you know, your CEO, your management people weren't saying the right things. You know, they all were kind of shirking. So very important that you have the right tone at the top. And you also have to have very concise written policies and procedures. Those written policies and procedures have to say that you require full compliance with all applicable rules, regulations, and requirements. As I said, you should also be updating employees on key changes in the laws or requirements as you go through things. Those written policies and procedures also have to have a mechanism for reporting violations. Depending on the size of your company and how many people are involved, there's all sorts of different ways to set up whistleblower, whether you call them hotlines or email boxes or whatever. But again, a key thing when the government comes knocking on your door is, what did you do to try to find these problems, to put a mechanism in place in advance to alert you to problems? Or were you turning a blind eye and just not listening to employees or others who may have brought this to your attention but didn't have the opportunity to do so? And finally, the other thing that has to be in your written policies and procedures is you have to actually document this and then follow through, and that is having thorough investigation of all potential violations. So you're going to have a triage mechanism. I understand that not every what I'll call employment issue is a compliance issue when it comes to government contracts, but you got to take the information in. You got to do a triage with the right people to know, okay, is this something we need to run down to ground and we're going to have to spend some time on? Or is this something that it's really more of a disgruntled employee issue that we can deal with HR? Sometimes it's a hybrid, and sometimes you don't know that until you get a little bit into it. You also want to make sure that you involve counsel in those types of investigations if you decide to pursue one, so that you preserve privilege. Everything's done in a way that if you decide to share it with the government, it's your decision to do so, and how it's all shared. All of that if you think it could be something that blooms later. Another part of your compliance program, as I alluded to, is having quality training. Your quantity is not so as important as quality training. Checking the box that people got trained every 12 months or 18 months or whatever it is. people don't want to waste the time to training, and it's really not effective unless you're talking their language, what they need to know, sometimes scaring them a little bit about the statistics because there is also a chance of individual liability. But make sure that your training really makes sense. If you're going to spend the resources to do it, spend them wisely. And then finally, effective auditing and monitoring. You can't just put the compliance program in place and then walk away from it, leave it on a shelf, and dust it off later when you need it. You really do have to go through regular auditing and monitoring of the system so that you can find problems before anybody else does, hopefully, and address them. The fact is, for any business to operate, they're going to have compliance issues. To think that you can put in place a compliance program and it will fix every single problem that's possibly out there is just not realistic. Instead, you have to have a mechanism for finding those problems, again, addressing them efficiently and moving on, learning from them. That's one of the most important things, learning from them and moving on. So, I know there's a lot of material and kind of a short period of time. I wanted to give you all a snapshot of what was happening in the false claims area. Any questions? Yes. The question is, how do companies actually pay the CMP, the civil monetary penalty that I was talking about? Is that the question? So that is something that's done separate from the contract itself. It is a negotiation with the government. If you're only talking, you mentioned the lower end of the penalty, that's usually not something the government's going to go after, frankly. It's usually successive issues or problems that arise over time, and the government will resolve that issue separately, and the payments will be made separately. So the question is whether or not the increase in the civil monetary penalties was really as a result of people not paying attention and there being rampant problems. So maybe this was a way to incentivize companies to comply better. I think actually it was a little bit of inflation and a little bit of perhaps what you're saying, incentivize. The biggest incentive, though, right now for companies to comply with the False Claims Act really is whistleblowers. They get a bounty for finding violations. And, private citizens obviously are everywhere. So while the government can't be everywhere, the private citizens are the eyes and ears, and they get money out of it. So that's the biggest way that the government enforces the False Claims Act. So the question is, do the people know that the government will pay a bounty for discovering a problem? Actually, the way the False Claims Act is, the money is paid by the violator, the defendant. They reach a large resolution with the government, usually a large dollar resolution, and then the whistleblower gets a percentage of that dollars that come in. It varies between roughly on average 5% and 11% of the recovery. It depends on whether or not the whistleblower actually proceeded to take that case forward all by itself on behalf of the government, or whether or not the government intervened in the action, because there's a formal process for the government to do so. And that's also usually a negotiation of how much the cut is of the whistleblower as well. It's very well known. I mean, there's lots of law firms, that's what they do as a practice, is represent whistleblowers. So yes, it's a big business out there these days. Other questions? So the question is, when does a business know, or when is the knowing requirement under the False Claims Act triggered? Is it a company-wide onus, meaning do you look at the knowledge of the entire company or just the individual who signed off? And the answer is a little bit of both. It is not limited, clearly not limited to the individual only who signed it, although they certainly are going to be the first person on the hot seat if they signed it. But more so than that, they're signing on behalf of the company. The standard really is what the company either knew or should have known by those persons who, not necessarily in management, but who are involved in the contract, and the government should have made, the company should have made a reasonable inquiry to. So it's not individual based. It's also not everybody based. That's a little bit unreasonable that you have to ask every single person down the food chain. But knowledge is imputed to the company based on the individual employees that make it up. Company can't act without its employees. The company itself, while as a legal fiction exists, it does not, have knowledge itself. It's based on all the employees. Other questions about the False Claims Act? Yes. So the question is, how are companies supposed to handle new information that comes up that makes a claim that was previously submitted inaccurate, even though it was accurate at the time in which it was submitted? So that is the classic reverse false claim. You have government money now in your possession, which maybe you legitimately got, but now the question is, do you have to pay it back because you realize there was a mistake or a change in circumstances that make it inaccurate? Happens in the healthcare context all the time. Healthcare companies, healthcare providers get reimbursed from the government and receive healthcare funds, and only later find out that there was some either accidental overpayment by the government or there was some mistake where they're now holding funds. And the government recently added the reverse false claims provision. I say recently, I lose track of time, 5 years ago, for that situation. So the simple answer is, yes, you're obligated to pay back the money once you realize that there is some falsity and you shouldn't have received the money. In practicality terms, what does that mean? You're going to have to make a risk analysis. How much money involved is one big thing. Can you simply just, refund the money back to the government, or should there be another process of disclosure so that you're not accused of making a false claim and it doesn't trigger some big investigation? When you find a problem like that is really when you need to consult with a lawyer to figure out the best way to self-disclose or pay back. Depending on the contract, some contracts have a mechanism just to immediately pay it back and no questions kind of asked easily. Those are easy. Others, you have to go through an entire process. Pardon me?
Add something on
that? Yeah, go right ahead.
So one thing I want to mention in connection with that is the mandatory disclosure requirement under the FAR. So it is a basis for suspension debarment if you fail to make a timely disclosure, if you have credible evidence of a violation of the Civil False Claims Act, and other criminal violations are also trigger or required to disclose, as well as receipt of a significant overpayment. So in terms of that requirement, again, you could be suspended or debarred for failing to make a mandatory disclosure if you have credible evidence, or if you or one of your principals, if the company or one of its principals, which is basically a manager, owner, director, has credible evidence of a violation of the False Claims Act. Well, as Jennifer just said, what is a violation of the False Claims Act? Courts can't agree, judges can't agree, lawyers can't agree, so how do you know? In the circumstance that was just raised, if you think that you might have an issue there, as Jennifer said, you might have a reverse false claims or false claims issue, you err on the side of disclosing, and it's not clear in the FAR who the disclosure goes to. It says the government. FAR clause, if you have a contract over $5.5 million with a period of performance longer than 120 days, your contract would also include FAR 52-203-13, the Contractor Code of Business Ethics and Conduct Clause, which also has a requirement to make a mandatory disclosure if you have credible evidence of a violation of the Civil False Claims Act. That clause makes it clear that your disclosure goes to both the contracting officer and the agency Office of Inspector General. So that is the best practice. If you want to get to them before they come to you, typically, especially if it's something that the government's aware of. One of the things that's been very big this year that I've been seeing recently are companies that represent in SAM that they're small based on the number of employees and their annual receipts. SAM then, based on their NAICS codes, tells them they're small. They go ahead, they're small. They realize that they're one subsidiary of a very large organization, whether it's a private equity fund or other large parent company that has number of employees and annual receipts way over the NAICS threshold. Therefore, they are not small, because when you're looking at whether or not you're small, you have to take into account all your domestic and foreign affiliates. In that case, it was a mistake. It was not intentional. It wasn't people not knowing how to use SAM, so then we go ahead and we make a disclosure to the government. And in that way, you get to put the story forth the way you like to, rather than just all of a sudden telling the government, hey, we're no longer small, all of a sudden we're large, and they start looking into it. You don't want them to start investigating. You would like to put the story forth your way.
Thanks, Erin. Any other questions?
You could do either. It just is timely. There's no definition for what timely is in the FAR. And oftentimes there's a two-step process that we'll do. So we'll make an initial disclosure. Hey, we think we have a problem. We're putting our marker in. So within a month or two, we think we have a problem. Government, give us some time to look into it. And then depending on how large an issue it is, the next 6 months to a year, you then look into it further and give a final description. So that's typically our process when we do it for clients. We do an internal investigation, and then we share with the government, this is what we found. It wasn't actually a violation of the False Claims Act. It wasn't done knowingly. It was just a mistake. Out of abundance of caution, we filed this, though, to get it out there. No, I'm sorry. The question was, some people might not know that they're small because they're doing work for someone larger. It's not that you are doing work with someone larger. It's that you're part of the corporate structure. So you're a wholly owned subsidiary of a large business. No, we'll talk at the break. Okay, we'll talk at the break, but the affiliation only applies in terms of ownership and control and influence. It's not applying to just contractual relationships. So, but we could talk more at the break.
No, that's fine. Any other questions on the False Claims Act? Pardon me? Sure. All right. I'm going to be around yet this morning, so if any of you have any questions, I'm happy to answer those on the break.
One other thing on the reverse false claims that I found interesting this year, too, I don't know if you've heard about the U.S. Landis versus Tailwind Sports case. This is a Lance Armstrong case and the Postal Service case. It was very important for government contractors as well, because the issue was that the Postal Service contract, which involved Lance Armstrong as being kind of their face for the Postal Service. He was fast, Postal Service was fast. And then it had an anti-doping provision, and then he was doping. So Postal Service said, everything you got paid for the sponsorship, we want all that money back. And they pursued it under the reverse false claims theory, saying that you breached the contract, you knew you were breaching the contract, therefore you owed us breach damages, and that is a reverse false claim because you owed us that money. Well, wait a second. There's a lot of contract breaches out there. Are you telling me now every breach of contract is a reverse false claims case. And luckily, there was a D.C. Circuit judge who said yes, and luckily, in January 2016, a different D.C. Circuit judge came back and said, no, that's not the case. If you have a breach of contract, it is up to the non-breaching party to decide whether or not they want to pursue that as a breach and whether or not they want to seek damages. So until you have an assessment of damages, some court has said it's a breach and here's damages, and you owe this money to the government, it's only then you fail to pay if you have a reverse false claims issue, not just any breach of contract. So I think that gives contractors some comfort. At this time, I have another lovely code to read for those of you who are on the phone and want CLE credit. The next code is 2, L as in lamb, T as in tiger, J as in jaguar, M as in mouse. That is 2LTJM. So for those on the phone and in the room, we are now going to let's take a 15-minute break. We're going to start back up at 5 of. So for those on the phone, you get a little bit of a break, and those in person, we look forward to networking.